Good evening and welcome to the Kuhn Academy for this installment of AP Government, Building Responsible Voters one video at a time. We have a couple special guests today in studio. First, we have Associate Justice Elena Kagan.
Thank you. I'm delighted to be here. It's a little colder here in Chicago than DC, but thanks for having me. And then I'd like to welcome Chief Justice John Roberts.
Very good. Thank you, Ms. Kagan. All right. So John Roberts, as Chief Justice, we're going to talk to you a little bit about how a case gets to the Supreme Court. All right. So we have a nice little cartoon here, poking a little fun at me and some of my fellow colleagues. Basically, right before Thanksgiving time from a few years ago. And we got a question for you on the next page here.
There we go. Would you like me to ask the question?
Please.
Okay, so which term is most closely associated with this cartoon? So take a look for a moment, and when you're ready, I will give you the answer. Okay, yes, it's the rule of 4. That's how many justices. There are 9 justices on the Supreme Court. That number determined by Congress. You need a majority for an opinion. However, to decide whether or not to take a case, 4 or more of the justices must agree. So at least 4, and that's known as the rule of 4.
All right, very good. So as we know, most cases in the Supreme Court are appeal cases, or come on appellate jurisdiction, as we call it. There's very few that are original jurisdiction. And Ms. Kagan, what kind of cases make it on original jurisdiction to the Supreme Court?
Okay, and we will look. That's good. I would like to clarify for a moment. If you'll remember, original jurisdiction is they're dealing with issues of fact, and those are in the trial courts, and then appellate jurisdiction cases on appeal. The Supreme Court is the only court that has both original and appellate. So, for example, a state versus state conflict. Several years ago, New Jersey and New York were suing over who owned the Statue of Liberty and Ellis Island. So it wouldn't be fair to go to a New York court, would not be fair to go to a New Jersey court, each giving preference to its own. So that went to the U.S. Supreme Court, and that's an example of original jurisdiction.
All right, now for appellate jurisdiction, all right, obviously if you lose a case in the Court of Appeals or a state Supreme Court, the case would either be dismissed and just let go, and the verdict would stand, or the losing side would submit what's called a writ of certiorari. Ms. Kagan, can you go over that Latin term for us?
Yes, it literally a writ, so think of a piece of paper in olden times, but a writ of certiorari, a Latin term meaning send up the records. So the person petitioning the Supreme Court, known as the petitioner, they request a writ of certiorari. They request a petition from the Supreme Court to hear their case. And if the Supreme Court grants cert, they're saying send up the records. They haven't made a decision. They're simply saying, yes, send up the records from the lower court, and we'll take a look at it.
And it's my understanding that you all will be doing a moot court of a case that's going to be argued before us in a couple weeks. So you'll be reading that writ of certiorari filed by Mr. Walker in the state of Texas. Okay, so after the writ of certiorari is then submitted and possibly accepted, it gets considered for consideration. We've kind of covered this before, but basically if 4 or more judges accept the case, it moves on. If there's less than 4, basically the verdict stands and the case will not be heard. So again, that's part of the rule of 4 there. All right, now if the case is accepted and 4 judges do accept the case, then a couple of different things can happen. So Ms. Kagan's going to fill us in on that.
Okay, so we could talk first about if the case is returned to the lower court for a new decision. So you remand it back to the lower court. Or I'm going to go to the right side of the screen here. The case goes for full consideration by the court. So that means there would be oral arguments. Each side would get 30 minutes to argue. Or in the middle here, the case is announced with a per curiam decision. And I believe that's on our next slide, so I can explain per curiam. Okay, so here's a question related to per curiam. Which of the following cases would most likely be written as a per curiam decision? If you look, all of these cases, with the exception of B, and B is the correct answer, Bush v. Gore. All of the other cases deal with some aspect of civil liberties. Now, Bush v. Gore is certainly a controversial case, but not with civil liberties. And per curiam means you don't have the majority, it's just as a whole, so you don't know the individual individual author of the majority opinion. These are usually 9-0 cases. Bush v. Gore was not. They're usually 9-0 cases that you want decided quickly and just from the bench as a whole. So there's no individual authors on the majority opinion if a justice doesn't want to associate his or her name.
Very good. So per curiam, or for the court, another Latin term you may see on the AP exam. All right. Now, after the court agrees to hear cases, sides are going to submit briefs. One of those would be called an amicus curiae brief, as Ms. Kagan's going to explain to us or translate for us what amicus curiae means.
Yeah, and you'll see what the Supreme Court and law in general, there's a lot of Latin terms, but amicus comes from the word friend. So an amicus curiae, a friend of the court brief. And those are filed on behalf of, or can be filed on behalf of, the petitioner or the respondent. So you're not actively involved in oral arguments, you're not a petitioner or respondent in the suit, but you have an interest in one side or the other. So you might argue as a friend, so an outside person, an interest group would be the answer there. You may argue why the court should side with the respondent or why they should support the petitioner.
Again, you'll be reading several of those next week in the Walker versus Texas court case. All right, so now once we have the briefs submitted, all right, we get ready for oral arguments. All right, so each side is going to submit briefs. You'll be reading these. Those are basically what the oral arguments are going to be in paper, and then the amicus briefs get submitted as well, and then it goes to oral arguments to the court, where Ms. Kagan will be sitting beside me as we hear these oral arguments.
Yes, and again, oral arguments are 30 minutes each side, so they're an hour long. Sometimes we hear 2 or 3 cases on Monday, Tuesday, or Wednesday during the session, which is usually October through April. After oral arguments then, so not immediately following, but we meet, the 9 justices, or those of us that heard the case, meet in what's called conference, and that's when we meet to discuss the case and make our decision.
And we have some very goofy traditions that go a long way back with how conference goes. And this really isn't something to be on the AP exam, but we kind of like to hear some traditions. So, Ms. Kagan, where do you sit in the conference room?
I'm a junior justice, so I'm the newest justice, so I am the furthest down the line. I'll let you speak, Chief Justice Roberts, as to the decorum.
And she gets the pleasure of speaking last. They speak in order of seniority, with the chief going first. I guess being the head honcho, I get that little perk. And then nobody else is allowed in the room, so conference is completely quiet, and Ms. Kagan has to sit by the door and tend to any messages or anything that comes their way. So it's a very archaic way of doing things and very traditional. All right, so we have another true-false question here for you about amicus curiae briefs you might see down the pipeline.
Okay, so true or false, an amicus curiae brief is a way to force the court to reflect public opinion. And look carefully here at the word force, and then I think you'll have your answer. Yes, it is false. So you're not forcing. The court is going to look at or base their decisions on their viewing of the Constitution and the issue involved. It's a way to get your opinion heard for either side, but you don't get to force the court to take a position either way. Then after we meet in conference and discuss the case, there are 4 possible types of opinions. That's where this part is public, so we write our opinion. So our legal reasoning, and there are 4 different types of opinions. Oh, and if it's a tie, then it would revert to the lower courts. And we can have a tie. Well, here's a question for you. I'll let you look these over quickly. So when would a tie occur, considering that there are 9 justices? You don't have to have 9 justices to hear a case. So when a justice recuses him or herself, you could have a tie. Justice Roberts, you were not on the court at that point, nor was I, but you want to discuss the VMI.
Yes, there's several instances where people recused themselves, but Clarence Thomas was noted for recusing himself in a case involving the Virginia Military Institute, where his son was a student. So he had a vested interest in the outcome and saw a conflict of interest, so he sat that case out, and that was only ruled with 8 justices. U.S. versus Nixon was another one. It was 7-1, and William Rehnquist, former Chief Justice, but at the time he was a newly appointed Associate Justice, he sat that case out because, take a wild guess who appointed him to the Supreme Court.
Politicking everywhere. So now we have the different types of opinions. And the first type, which I don't know if it's, there we go, is a unanimous opinion. So there, all of the justices, if it's 8, if it's 9, usually it's 9, but whoever heard the case, as many of justices, they all agree. If the decision's unanimous, then that means the Chief Justice is among them, so he or she, in this case Mr. Roberts, would get to assign who would write the opinion. Again, the opinion is the written opinion of the court. If it's less than unanimous and the Chief Justice is in the majority, then the Chief Justice assigns someone from the majority. So it can be 8-1, 7-2, 6-3, or 5-4. A concurring opinion means if you concur, you agree, but for a different reason. So you're a member of the majority, so you agree with the side that the majority, so you concur if the majority agreed with the petitioner, or you concur that the majority sided with the respondent, but for a different reason. And again, in writing, in a concurring opinion, you explain that. If the decision is not unanimous, then you will have minimally a dissenting opinion, and you can have several. So those are the justices that are not in the majority, therefore they're in the minority, and they explain why they disagree in writing with the majority opinion. So these are 4 possible opinions you can have written by this court.
And unfortunately, Ms. Kagan's written some majority opinions, and I've written some dissents on the opposite side, and vice versa, so seeing as we're from opposite ends of the spectrum, but at the end of the day, we're all on the same team. All right, and we'll wrap things up with one more question here for you, and then send you on your way. So, Ms. Kagan, let's take them home.
Okay, let's go home, folks. In the current Supreme Court, when would the Chief Justice most likely not assign the writing of the opinion? So, and if you'll take a look, and the correct answer is... Where are we here? I need to read too. In a case limiting, that would have nothing to do. In a case favoring states' rights. In a case, there we go. In a case limiting the use of the death penalty. So, and do you want to explain why that's the correct answer?
Yes, being somewhat conservative, after all, I was appointed by George Bush, I'm tending to be pro-capital punishment. So if there's going to be a case limiting the use of the death penalty, as there could possibly be in a couple weeks regarding a mentally retarded accused criminal who's sentenced to death, I may be in the dissenting side of that opinion. So I would not assign the majority. That would actually fall on Stephen Breyer more than likely, or Anthony Kennedy, who are more senior justices and the majority side of things. All right. So thank you very much, Ms. Kagan. We appreciate your time.
Thank you very much. Thank you very much, Chief Justice, for being here.
All right. Thanks for listening to Kuhn Academy, where we are building responsible voters one video at a time. We're going to send you home with a little Uptown Funk.